Good morning, good afternoon, good evening, wherever you are in the world. I'm from Melbourne, so it's a good morning for you. I'm Dr. Rajesh Sharma, and I teach here at RMIT University. I'm very thankful to the organizers, mainly Colin, to invite me to take part in India-Australia FTA seminar. It's my really pleasure to be here. In this context, I just want to say that India and Australia have been negotiating this trade deal for a long time, and it has not been completed yet. The two big economies, two good friendly countries, and still it has not been completed is really a kind of not a good idea and not a good scene that why India and Australia has not completed despite having good intention. No matter what, wherever we are today, but in the context of Australia and India, I just want to make few comments that negotiators in the deal making, they can take into account of that. The first thing I want to mention is that Australia, India should decide that they will negotiate the dispute resolution rules in a different committee and not combined with the rules committee. Generally, what is happening is that in most of the negotiations, we see that the dispute resolution mechanism, they keep it in the rules committee. And one rules committee decides all the part of the negotiation, including the dispute resolution. So what happens is that at the end, when they are discussing about dispute resolution, not enough effort or the discussion or thoughts have been put into that. In this way, it is not going very well. And that's why in every FTA which is negotiated around the world, we see that the innovations in the dispute resolution is less. Take an example, TPP has shown some kind of difference or some new provisions in dispute resolution, which we didn't see before. And after TPP, we have seen many other FTA has included or have included different provisions or some innovative provisions. So what we need to look at it, all the two partners, whatever they want to achieve or they want to suggest in the WTO, they can also think about that, how they can implement it and include it in the FTA, particularly in India, Australia. So some innovative provisions can be included in that if they will include or they will discuss this one under the rules committee, not in the rules committee, but in the dispute resolution committee. So my first recommendation and suggestion is that the negotiator should create a team who will only focus on the dispute resolution provisions, and that includes the ISDS provision. In that way, their focus will be on the dispute resolution alone, and then it will be a very well drafted or very well crafted dispute resolution mechanism will come into that. If it is agreeable, then we can even learn from ASEAN. As it happens in ASEAN, the dispute resolution framework is agreed before. So in the same way, if it is possible, then Australia and India can even agree on the dispute resolution framework first, rather than to leave it at the last. And in fact, in one of the RCEP negotiations, when as an NGO, I was involved in that, and when we were making this argument that how the dispute resolution the structure should look like in RCEP, we were told at that time that the RCEP partners have already agreed on dispute resolution, which was quite early in the negotiation. And that was really surprising because we don't know like how much it was well thought about it, or they just consider it's not a non-controversial issue, so therefore we can agree on that. I sincerely disagree with that kind of an approach. My approach is that, or my suggestion is that we should focus very well on that, because somebody, a very well-known person, has said that the benefit of good FTA can only be reaped if the dispute resolution mechanism is correct. And that we can see even in the in the investment provisions. If investment dispute resolution process is not correct, then the benefits of investment or the protection of investment cannot be given to the investors. And therefore, I suggest that we should have a committee, a group of experts in dispute resolution to negotiate India-Australia FTA and look into the state versus state and also the investor-state dispute resolution. Now, my second resolution is that, or second suggestion is that, that all the timelines which is given in the dispute resolutions mechanism, generally, if we look at that, we have no idea or there's no commentary, or there's no reason given that why a certain timeline has been accepted. For example, if consultation is required, we see that consultation should be given for 60 days. But one may argue and question that on what basis we agree on 60 days. Is it for some reason? Is there any logic behind that? Is there any reason behind that? Or is this a number we have picked up with that? So if 60 is correct, then why not 90 and why not 30? So we need to have some kind of a discussion. I can agree that the government can decide that in order to engage in negotiation, they need to go through the cabinet, they need to go through the committee, they need to get the permission, and that may take 30 days time. So at least they should have more than 30 days time. If that is the reason, then we should see that all these things should be recorded, and at least it should be noted somewhere that it should be more than 30. And if that is correct, then the same country, while negotiating the FTA with other countries, they should maintain the same line, same consistency. In my research, when I wrote my book on dispute resolution in FTA of India and China, and I was looking at that, what could be the possible dispute resolution mechanism. In that one, I was very surprised to see that India or China or any other country like Singapore or Australia and other, when they are signing FTA with different countries, even one country with different countries, when they are signing, the provisions, the timelines, all are different. There's no consistent discussion on that one, or a consistent line or timeline has been given. It also shows, to some example, like if you look at ISDS mechanism, where it has been reviewed quite extensively, we see that in some of the BITs on FTAs in investment provision, the waiting period is given 90 days, 120 days, 180 days. One may question that why these days has been given. Is there some reason that they think that local exhaust or local remedy can be exhausted in 120 days or 190 days or 200 days? There's nothing has been said about that. So we need to have some rational thinking about these timelines. And the reason I'm saying it, and this point has been picked up by Ansatral in working group 3 when they are reviewing ISDS provision, the discussion is about whether we should have a appellate body or other changes or not. And in that one, the WTO has been taken as a standard to see that how WTO has maintained its timeline. And there is a research is being done by a group of academics in that, which will be submitted. And I have been fortunate enough to be joined in that one. And we have just finished the research on that one. And I can tell you that the earlier data has shown that in last 10 years, WTO dispute resolution system has not maintained or met the timeline. They have always overshoot. And in some cases, it has gone beyond 1,000 days. So we can understand that the timeline which was set at the time when the rules were drafted, whatever the reason it was set, it is not matching now. Or maybe the content or the dispute has become so complex that the arbitrators or the panelists need more time. If that is correct, then it is time for us to look back now and think about that when Australia and India in their FTA, when they put the timelines, it should be practical and rational and well thought about it, not just taking from any draft and just put 14 days or 25 days or 30 days or 60 days without any rational thinking. So we need some kind of a rational thinking in that timelines, which is very important. And now it is becoming very important. Now, my third point, which I want to propose in the drafting or in drafting of dispute resolution mechanism, is that all these texts are negotiated by the bureaucrats. And some bureaucrats may have the legal background, some bureaucrats may have a linguistic backgrounds. But my suggestion is that when the draft is ready, or in principle it is ready, then that draft must be vetted or reviewed by legal linguists. Legal linguists' view on the draft is very important, because what we as a lawyer see in a word, the same way other people may not see it. So we have to have some consistency. And a good example is Turkey and Turkmenistan BIT, where a word that provided that if, and that word, or provided if, that word has caused so much of dispute that in one case, they had to hire more linguists than the lawyers. So we do not want to have that same kind of a thing. The lawyers and the linguists may have a different views in that. And one linguist or one legal linguist told me about that. That is a good example is that if you want to know that how lawyers see the word and how they see the words is totally different. For example, what is the difference between the word finish and complete? Lawyers may take out the Vienna Convention of Law of Treaty and then start interpreting that. A simple linguist can just take out the dictionary and they can see the meaning. But the legal linguist said that, let me explain you what is the difference between life, finish and complete. It says that if a man marries to a good woman, then the life is complete. If a man marries to or the partner marries to a bad partner, then the marriage is finished. So they say that it's not complete. But if a good woman finds a man with a bad woman, then the life is totally finished. So in that context, the whole same word can be interpreted in different ways by different people. So it is important that every draft of the language of the dispute resolution or any provision must be vetted by the legal linguists. In 2015, when there was or 16, there was a program in University of Melbourne, and it was organized, and the DFAT of some staff were there, and there was a discussion on the provision of Australia, Indonesia, BIT or the FTA, and the language was being discussed. And I recall the DFAT staff really looked at us and said that, okay, if the language is wrong, then you write one paragraph and give it to us and tell us that this is complete. At that time, I don't think that we drafted any paragraph and give it. As a lawyer and as an academic, we always criticize that whatever the language is given, but we have to give a solution. What is the tight language for a provision? We have to come and give it to that. So I suggest the third point is that we should look at the language in that. If we have a good dispute resolution mechanism or the team who is working on that, that team will be in a position to really create some innovative ideas in the dispute resolution mechanism. In other words, the dispute resolution mechanism should be practical, it should be effective, and it should be implemented nicely in that sense. So if you want to make that, and at the same time we have to create some innovation, we suggest that we can have that. And one example is very clear that even in UNCITRAL now, in working group 3, there's a proposal that we should have an appellate body or appeal mechanism for investor dispute. But most of the FTAs has not included it. So why not India and Australia come forward and think about that? Should we have that? Even if not ISDS, a state versus state dispute, if we look at that, in WTO system, we have appellate body. In FTA system, we do not see appellate body. So why is there any restriction that we cannot have it? Then they can be courageous enough, bold enough to come out and give an idea about to have an appellate structure in the FTA itself. There's no harm. We can always keep that. And that will make it very consistent approach of that. Of course, we know that the FTAs do not see most of the disputes coming to them. But if and at all, if it comes, then at least we will have a good mechanism to deal with that. We do not have to devise a mechanism at that time. So that's why the innovation, the first thing is that one appellate body. And the ISDS also in this decision making, we can include a couple of things extra. Particularly for developing and developed countries, there's one thing is that when an investment dispute comes, we always look at the legal side of it and we apply the law, and then we decide who is right, who is wrong, and who has to pay, who is winning. But in the whole process, we miss out one point, is that every investment which is done in a country, it is for certain purpose. My view is not that like what we look at the definition of investment, but what I'm looking at is that the impact of the investment on the country, on the citizen, and the region. We have to look at that. For example, if a road is constructed from one country which is passing to another country and going to other railway line to go crossing the 2-3 countries, if one side of the road is not made or not completed, then the different country will not get the benefit, or the people from different country will not get benefit. So if the power project is being constructed, road or bridge is being built, that investment, even there's a problem, if the dispute resolution happens, the panel or the tribunal should consider the impact of the decision on the country, the people of the country, and the region, the benefit of that. And accordingly, they should decide that, or at least while making that decision, they should keep that factor in the mind. Or whenever it says that take into account of any circumstances while making this decision, then the tribunal should take the impact of their decision or the benefit of the project of the country and on the citizen and the region. They should keep that one in account. That will be a very good idea to include that. Particularly at this time, because Australia-India FTA has stalled for a while. Since we are in this time, we should take advantage of the new development. Australia particularly has done very well in developing hydrogen trade. Hydrogen trade is a new factor, it's a new trend, it's a new thing coming. So why not to take advantage of that situation and learn from Australia, and India can join together and they can create a hydrogen trade mechanism in their FTA, which they can include it, and that will be very good in that sense. And lastly, as a part of innovation, I suggest that like NAFTA, it's a good idea to have every FTA to have an FTA committee kind of a thing, which has a superpower kind of. If panel or the arbitrator has made a decision or interpreted a provision of a treaty or the FTA, or which is not intended by the parties, meaning Australia and India, if it is going beyond their intention, then in that case, FTA committee, through the consultation of both sides, that committee should have the power to annul that decision of the tribunal. This should be a final trump card, which can only be applied when the two countries join together and decide in the same way. Otherwise, there is no need to intervene in that. But this situation should be there, because we never know that that Australia-India agrees today, that may or may not be accepted by the others, or the arbitrator or panel member may not understand and interpret in a totally different way. That will not be a good situation. So with these suggestions, I close my submission and close my paper for you to have a thought on that, so that we can make an Australia-India treaty, FTA, a better one, a more practical one, more effective one, and more efficient one, particularly this dispute resolution mechanism. Thank you very much.